Welcome to Minding the Forest, a podcast of the Louisiana Forestry Association. Hello, I'm your host, Jeff Zeringue. In Minding the Forest, we talk about forestry, the importance of managed forests, and the many aspects about the forest products industry. Forest owners, loggers, and wood manufacturers such as lumber, paper, and pellet mills all play an important role in the conservation and management of forests for the important renewable natural resource it is. Managed forests offer more for wildlife and water protection, so the LFA advocates to keep forests as forests. This episode of Mind of the Forest is sponsored by First South Farm Credit. First South is your premier rural lender. With over 100 years financing timber and agriculture, they have the expertise you're looking for when financing rural property. If you're looking to purchase or refinance land, call your local First South Farm Credit office or find them online at firstsouthland.com. This is episode 51 of Mind of the Forest. We have two guests, Tom Manuel, who is a forester and wildlife biologist, and James Knight, who is an attorney for the Institute for Justice, a nonprofit law firm based in Washington, D.C. Tom has an active lawsuit against the state of Louisiana pertaining to how wildlife and fishery agents are trained, and it deals with private land ownership rights. James's nonprofit firm has taken up that cause. Welcome to Mind of the Forest. We're talking with Tom Manuel. Tom is a forester and wildlife biologist from Ethel, Louisiana. And on the phone with us today is James Knight. James is an attorney for the Institute for Justice. James, Tom, welcome.
Thank you. Good morning.
Good morning, Jeff.
James talks to us from Washington, D.C., where the Institute for Justice is housed. James, tell us a little bit about who you are first, and then we'll get to Tom, and we'll let Tom tell his story.
Sure. My name is James Knight. I'm an attorney with the Institute for Justice. The Institute for Justice is a nonprofit law firm that protects people's constitutional rights and freedoms throughout the country. One of our issue areas is the open fields doctrine and Fourth Amendment more broadly, protecting people's right against unreasonable and warrantless searches throughout the country.
Okay. And Tom, tell us a little about yourself.
Okay, so I'm a consultant forester and wildlife biologist at Manuel Forestry, LLC in East Feliciana Parish, and work in Southwest Mississippi and in the Florida parishes. And
you've been doing this for how long?
Since 1992.
Okay. So you're probably wondering why a lawyer and a forester are in the same show. Well, we're getting to that right now. Tom, in Forest and People, the magazine for Forestry Association, for Louisiana Forestry Association, did a story concerning what you encountered in 2023 while you were out hunting on your own property. So let's just get right into it. Tell us what happened that day.
Okay, so I was deer hunting in December on land that my wife and I own, and in the morning, and I didn't kill a deer. When I got down from my stand mid-morning and walked back to my truck, there was a game warden there from Department of Wildlife and Fisheries. He was parked right behind my truck. And what's important is that my truck was not visible from a public road. It was not parked on a public road. It was well inside my property and out of sight. There was no way to know my truck was there without coming on my land to look for it. So, but anyway, I approached the guy and asked him if there's something I could do to help him, and he said, "No, I'm just here to check on you." I asked him to, maybe he could wait for me at the gate. He did not want to do that, and so I told him, "Well, I'll put my rifle in my truck, and then I'll talk to you." And he said, "Well, why don't you give me your rifle?" And at that point, I was, just a little concerned. I said, "No, sir, I'm not giving you my rifle. I'm on my land. This is my rifle, and I'm going to unload my rifle, put it in the truck, and then I'll talk to you." And
It was very safe practice, though, to hand a loaded gun to someone else, is it?
Yeah, it's really not. So, I didn't know him. I'd never seen him before, and I just didn't see where he needed it. So he backed off of that. I could tell he probably didn't like it, but I put the gun safely in my truck and then talked to him. And he checked me I was wearing Hunter Orange. I had my license. He went through all the things they would normally check. I had deer tags. I had electronic deer tags, but I had switched away from the paper deer tags. And we went through a little bit of a back and forth on that, where he kind of tried to get me on a technicality there. But ultimately, he said I had to prove myself to him that I had the electronic tags, which I did. I called in and proved it to him. But anyway, when we were finished, I asked him if we were finished, and he said yes. And so I said, well, let's take a minute. I want to talk to you about what I do for a living. All I do is work on private lands with private landowners. And I want to talk to you about constitutional rights of landowners, and where basically I let him know where I think you're messing up. And we had what I call a spirited conversation, but it wasn't ugly. And when we finished, I could tell he did not like having his authority questioned at all. But he left. I didn't get a ticket. He left. And I knew that I think the reason I knew that this issue was a problem is because I had been reading. I read several journals, and I had read in the Alabama Forestry Owners Association magazine about a lawsuit in Tennessee that where a farmer was had a lawsuit filed against the state of Tennessee. Wildlife agents had come on his property without a warrant and put up cameras. And so I knew a little bit about it. I knew it was an ongoing lawsuit. I did not know about the Institute for Justice at that time. But later that day I Googled that. I was curious about it, and I saw the Institute for Justice. And I began to think more about it. And I knew I probably had, standing at that point to do something about it. But it was one time. And I thought, I think I'll probably just let it ride. But 2 weeks later, I killed a deer one morning, and I sent in my electronic tag information to the state, which lets them know that I killed a deer, which is fine. I'm a biologist. I think it's fantastic to have the knowledge of what's actually harvested. But coincidence or not, that day, 2 more agents came out to my property and did the same thing, very similar.
While you were hunting?
I was not hunting. I'd killed a deer that morning, and I didn't go back. Now, had I gone back and killed another buck, I would have been, breaking the law, but right. I did not go hunting. Didn't want to kill another deer. It's my contention that they came out there because of that. They were kind of watching me after I'd pushed back on the first guy. Don't know that for a fact, but if not, then it's extremely coincidental. So my brother went hunting that afternoon, and when he got down from his deer stand after dark, there's 2 agents out there by his truck. And when he asked, he texted me immediately and said, hey, there's some game wardens back out here. And I wasn't far away, so I headed there. But before I got there, he talked to them. He didn't get a ticket. He was doing everything properly. He asked them, what's your probable cause for being out here? And one of them told him, well, we assume that you're deer hunting. And he said something like, well, I was deer hunting, but that's not illegal.
Yeah.
What's your reason for coming out here? And they said, we have known for many years that where y'all park on this property, which gates you use and don't use, which roads you use and don't use. They told him a number of things like that. But same as my encounter, it didn't devolve in anything bad, and they left. Well, as they were leaving, I arrived just outside my gate on this little road where our place is. And so I talked to him, and I let him know. I said, I'm going to thought to myself, I'm going to record this. And so I did, and I let them know. So I'm going to record our conversation. And so we talked to him, and there were just a few key things there that that were very telling to me. One is that I had received a ticket one time, nearly 5 years prior, on a different piece of property, and one of the agents that had been there, but he had not talked to me nearly 5 years prior, 4.5 years. So he, yet here in the dark, he was saying this was totally coincidental and random that he'd been out there. He didn't know who I was. They weren't checking on me, but he told me that he knew my name and where I had been in 2019, whose property I was on, and that, again, they had kind of been watching our gates and our roads and where we park, and we're not outlaws and don't feel like we deserve that.
Yeah, I could see where that might give you the impression that it wasn't a coincidence.
It gave me that impression, and I still have that impression. Another thing, and there's a good bit that we talked about, but I was really, my whole contention all along is that it's not so much what they did, it's that the Wildlife and Fisheries, my state, is training people, training them, equipping them, arming them, and sending them out onto private property to violate people's constitutional rights. And I asked them something to the effect of, is this what you learn in the academy? And they said, oh, absolutely. I said, if it's a known hunting property during the hunting season, we go on in an open gate anytime we want to. And there's much more than that. This has nothing to do with being a known hunting property, which there's really no such classification. They believe they can go on any land that they want to, open gate, closed gate, whatever, stay as long as they want. And it's clearly in violation of the state constitution. So that
second incident is what motivated you to contact the Institute for Justice?
It did, yeah. And so that is why ultimately I became involved with them and filed this lawsuit.
James, what was your impression when you first heard Tom's story?
Well, Tom's story is very troubling for us, but unfortunately not surprising. All across the country, there's wildlife officers who act this way and will go on to land without a warrant, without any probable cause to believe that a crime is happening. The U.S. Supreme Court has unfortunately said that the U.S. Constitution doesn't protect landowners there, but the Louisiana Constitution is different. It's broader and it protects all property from warrantless searches, and land is property. The reason that property is specifically protected in Louisiana is because when Louisiana adopted its 1974 Constitution, it specifically rejected the approach that federal courts took, where some kinds of property were protected and some weren't. In Louisiana, all property is protected, including land. And so we were, of course, happy to help Tom challenge the game warden's use of their authority to go into his land without a warrant in Louisiana.
Well, the federal approach to that, as you said, the Fourth Amendment clearly says we have the right to our privacy and our own property, correct?
The federal Constitution, we believe, should protect people's rights in their land as well. But unfortunately, the U.S. Supreme Court has not interpreted it that way. There's a difference in wording. The Fourth Amendment talks about your right in your houses, papers, and effects. But Louisiana specifically just protects all property. Now, we think the federal Constitution should be interpreted to protect private land as well. But unfortunately, the Supreme Court hasn't interpreted it that way right now. But the Louisiana Supreme Court has said that private land is protected. Soon after the 1974 Constitution was adopted in 1978, it held that open land is protected. You only have to read the Louisiana Constitution to know that. But that decision was in 1978. And in recent decades, game wardens have been ignoring that ruling, even though the Supreme Court never changed their decision. What Tom is asking the courts to do is remind game wardens and all law enforcement what the Constitution says.
The federal case, just to review, because I want, if folks want to look it up, they can find out more about it. That refers to the open field doctrine, which is a ruling from 1924, I think you had said.
Yes, that's Hester versus United States. That was the first U.S. Supreme Court case that adopted the open fields doctrine.
And so there's been subsequent rulings that use that as precedent?
Yes, the U.S. Supreme Court reaffirmed that interpretation of the federal Constitution in 1983 in a case called Oliver versus United States. But the Louisiana Constitution is different, and the U.S. Supreme Court can't interpret the Louisiana Constitution. Louisiana is free to provide greater degree of liberty and protections than the federal government does. And that's precisely what Louisiana chose to do.
Is there a conflict between what the Constitution says and the laws that that have been enacted that allow agents certain privileges, if you will?
Specifically with this issue, if only the federal Constitution applied under current law, under the current decisions of the U.S. Supreme Court, the game wardens could do this because it's open land, not directly next to a house. Now, again, I don't know if that's the best interpretation of the Fourth Amendment. The Fourth Amendment was designed to protect privacy on property, and so it really should apply. But thankfully, in Louisiana, you don't have to rely on the federal Constitution. The states can't provide less protection than the federal Constitution, but they can provide more, and that's what happened here.
Okay. So, have you been involved in any other cases in any other states that talk about this particular subject that talks about private property rights?
I have not personally been involved in other cases with this specific issue, but the Institute for Justice has. We have that case in Tennessee that Tom mentioned that we actually won recently at the appellate level, and the state chose not to appeal that decision higher. In Tennessee, the language is a little different, but it's the same basic issue where the Tennessee Constitution has broader protections than the federal Constitution, and that state Constitution protects Tennesseans from wildlife officers coming onto their land without a warrant. We also have similar cases in Pennsylvania and Virginia that are still ongoing, again, under their state constitutions, which provide a greater degree of protection than the federal Constitution.
Well, what do you suppose wildlife and fishery agents, and not just from Louisiana, but this seems to be more broadly done in other states as well, why do you suppose they feel they have that authority?
It's hard to say why they think they have it. They may be relying on the federal Constitution. They may be relying on some other court decisions in Louisiana, but those decisions don't address the underlying constitutional issue of whether you can go onto private land. So it's a misinterpretation of law. And it's easier for them. If they don't have to get a warrant, don't have to have probable cause of a crime, it's certainly easier to just go on any land that they choose. I think what Tom's point earlier on the training is important. These officers, this isn't a case of rogue wildlife officers kind of going off book. This is what they're trained to do. They're following their training, but it's the training that's wrong. Oh. And police are able to enforce all kinds of laws that are broken inside people's homes by getting a warrant first. Game wardens can do that too, and that's what the Constitution requires. And we actually see that in other states that have rejected this open fields doctrine that allows officers to go on without a warrant. In neighboring Mississippi, only 20 minutes down the road from Tom's house, the state Supreme Court held that you need a warrant to go onto private land, even wooded land like Tom's, in 1924. It's been 100 years where wildlife officers need a warrant to go onto private land, and their wildlife populations are thriving. Tom could speak to that better than I could. But there's several states throughout the country where this is shown that it's not a problem. They don't need this authority.
Tom, in the past couple of years since, well, it hadn't been 2 years, but about a year and a half. So in that time, have you had any other encounters with wildlife fishery agents on your property?
No, not on my property.
Okay. Have you heard of similar stories? I mean, you didn't just approach just from, willy-nilly. I mean, I'm sure you've talked to friends or folks, huh? Before
absolutely,
you did this?
Yeah. So when the first guy came out and talked to me, I had read recently about the case in Tennessee, but I'm also informed by my career, 30 plus years of doing this. And, I know so many stories that it's incredible. The number of people in this area where I work, clients of mine all my clients are landowners, landowners who are not my clients, but are just friends that, I've known stories, I've known of encounters for years that, and I'm not talking about outlaws. I'm talking about good people, who provide wildlife habitat, who, provide, timber, jobs, logging, just tree farmers and hunting leaseholders that have had so many encounters with agents that kind of fall into this category. So, yeah, I've known about that for a long time, and I've learned a whole lot more in the last year or so because people have just called me and told me, hey, this is what happened to me. So, yeah, I'm very aware of it. And to James's point about Mississippi, which does not permit warrantless search and seizure like Louisiana trains their people to do. Mississippi's got just bountiful wildlife, at least in the parts where I work. They're deer, turkeys. They're just really doing well. So obviously, to me, allowing agents to come on the land without a warrant is not necessary. It's not a limiting factor for wildlife populations.
Just to kind of backtrack a little bit, you have encounters with other agencies within wildlife and fisheries that you have, they've been positive experiences, like the wildlife biologists and things of that nature, haven't you?
I do, yeah. I'm first of all, I'm pro law enforcement, totally. I'm not at all opposed to proper law enforcement. But yeah, the wildlife and fisheries is divided the way I understand it. There's an enforcement division and a biology division. And the biologists, I've known many of them, went to school with some of them at LSU. And they are first-rate biologists, and they genuinely care about our state and its resources. And yeah, I'm 100% behind them. So, and I've worked with wildlife and fisheries over the years. I've never had an axe to grind with them or anything like that.
James, I'm sorry. Go ahead, please.
I was just saying, the way I understand it, that Louisiana's division between the enforcement and biology side is a little unusual. In states, it's more common for officers for wildlife enforcement agency, whatever it's called, to have kind of a dual purpose, be biologists who are also enforcing laws. And I think that difference might be skewing the way that they approach enforcement of hunting laws here. It's not biologists kind of looking out for wildlife. It's a kind of separate law enforcement agency that aren't trained for biological purposes or wildlife management. It's out there to kind of write tickets.
Okay. In having experience with your encounter in talking with other folks, is this the kind of lawsuit where others can or even should join in with Tom? Or is this, Tom is just fighting the battle because of his experience and he believes in private property rights?
It's the second. Tom is fighting this battle because it's important to him. I think one thing that Tom mentioned from the outset and that we certainly agreed with is that we're not asking for money damages in this lawsuit. It's just about the court clarifying that wildlife officers need to get a warrant before they go on private property. So if we win this case, which we're optimistic and believe we will, then that will protect all landowners in Louisiana.
At what stage is the lawsuit?
We're still in the trial court right now. Okay. So we've been in what's called discovery, where we're getting evidence from the state and they're asking for evidence from us. The next stage would be going and asking the trial court to rule on our claims. And whatever happens there, either side can then appeal up higher up through the courts. And eventually we could get up to the Louisiana Supreme Court and ask them to clarify the law here. And we would hope uphold their decision in 1978 that said that Tom's land should be protected.
This is, it's a lengthy process, isn't it?
It is. There's a joke that every American gets their decade in court. And so we're hoping it'll be less than that. But unfortunately, the court system's not very speedy.
Wow. Yeah. Well, just for our listeners' information, we have, when we did the story in Forest and People last summer, we have reached out to Wildlife and Fisheries, and as expected, and it's not really uncommon, they've declined comment because they are in an active lawsuit. And it's been my experience in journalism before is government does not comment on litigation until litigation is completely done. And even then, the comments can be slim. So where do we go from here? So you're in discovery. Tom, I'm sure Tom, are you deposed by both your attorney and attorneys, or does that all happen at the same time?
Yeah, I was deposed by the state,
Mm-hmm.
by their attorneys.
Okay. So James, is the deposition, is that when everybody is in the same room talking? I mean, you're present during that as well, aren't you?
That's right. That's right. With the deposition, everyone gets in a windowless conference room for a long day, and lawyers can ask whoever's being deposed questions. And when Tom was being deposed, I'm of course there, and to make the objections you need to make. But the depositions they're not the most exciting part of the lawsuit, but they're important. It's when you can get evidence on the other side. We deposed members of the Department of Wildlife and Fisheries last year. And so now, once discovery is over, the next step is us filing a motion to court to ask them to rule on the case. And then the department might file its own motion, but either way, they'd be responding to our motion, and that's when you would see kind of their approach to the case.
Is this a case that would be taken up by the judge, or this is something that could go to a jury?
That we don't know for sure whether this would go to a jury, but these are primarily legal issues. It's kind of interpretation of what the law means. There's not a lot of disagreement about what actually happened on the ground here.
Right.
And so those kind of issues are usually resolved by a judge.
Okay. So it's unlikely to go to a jury is what you're saying?
That's right. I mean, you can never know for sure, but these are primarily legal issues.
Okay.
And so we would expect that the courts to be resolving.
Well, curious, how does that decide? Does a judge decide that? Do you request that? Does the state request that? I mean, how does that work?
Sure. So when discovery is over, either side can file what's called a motion for summary judgment. And what that means is that you tell the court, if there aren't any disputed facts, you can just look at the record that both sides agree to and decide what the law is based on that record. Mm-hmm. And so that would be the judge determining whether or not the Louisiana Constitution protects Tom's land against warrantless searches. Whatever happens there, either side can appeal that decision higher up. There's an intermediate appellate court that appeals can go to first, and then there's the Louisiana Supreme Court.
Okay, so this is filed in Baton Rouge, I assume?
That's right.
Okay, so any appeal would go to the First Circuit, and then from there it could go to the Supreme Court.
That's right. The one, this gets a little technical, but the one caveat is that if we win in the trial court, then the state can skip the intermediate step, is my understanding, go straight to Louisiana Supreme Court.
Oh, so the state, if you win in the district court, then the state would have to request it to go straight to the Supreme Court if that's what they want.
Yeah, that's my understanding. And it'd be, of course, it's up to them whether they appeal, and this is all kind of down the road.
Okay.
Yeah, so the first step is going to the trial court.
Okay. So once the decision is made in the district court, if you have to appeal, then you going to appeal to the appellate court. If the state has to appeal, then it has the option to request to go to the intermediate or straight to the Supreme Court. Is that correct? That's right. And it depends a little bit on how the decision comes down. There's a lot of ways that a judge can kind of resolve these issues. There's always the possibility that the judge wants there to be a trial. Trials are to resolve factual issues. And so if the judge thinks that there's some factual issues that she'd like to see resolved, then we could go to trial. But so it's always hard to know, but you've got it right. Okay. All right. Tom, I know you've heard stories from other landowners and other folks who've had similar experiences. What advice would you give them, Tom?
I would advise them, and I'll back up just a second. I'll tell you, I've known a lot of these instances. They don't even all involve hunting. Sometimes people are just on their property. I know people who do not hunt who've had game wardens on their property and start questioning them about stuff, back, on their land. So you don't even have to be hunting. You just have to be there. But I think that I'm very glad that I recorded the instance with them. So I would advise that. I think it's probably a good idea to just let them know. And then if you got a cell phone with you, which most of us do now, just record what you talk about. And that way everybody's on the same page if anything does come about it. I also think that, and then James can correct me if I'm wrong, but I think that you're probably well within your rights. If you see any government agent on your property, you're going to ask them for their warrant. May I see a copy of your search warrant? And, today's date and time in Louisiana, they're probably not going to have one if it's the wildlife and fisheries, but at least they know what you're thinking of. And, be courteous as always. Most of them are pretty courteous people as well. That's kind of the advice I would give.
James, what about you?
I think that's all exactly right. I mean, Tom's right. This case is about much more than just hunting. It's about Louisianans' right to privacy on their land. The same constitutional right that Tom is asking the courts to enforce against game wardens is the right that protects everyone from police coming onto their land without reason, without a warrant. And so that's really what we're asking the court to do is just, it's not saying that game wardens can't come onto private land, it's saying that they have to have a reason to do so and get a warrant from the judge.
Okay. If anybody would like to have more information about the Institute for Justice, where should they go, James?
Go to our website, which is ij.org.
Okay, ij.org.
That's right.
James, thank you so much for joining us. James Knight, who is an attorney for Institute for Justice based out of Washington, D.C. Tom Manuel, forester and wildlife biologist. Gentlemen, thank you so much for joining me today.
My pleasure.
Thank you, Jeff.
Thank you for listening to Mind You the Forest. This episode was sponsored by First South Farm Credit. First South is your premier rural lender. With over 100 years financing timber and agriculture, they have the expertise you're looking for when financing rural property. If you're looking to purchase or refinance land, call your local First South Farm Credit office, or you can find them online at firstsouthland.com. If you'd like to learn more about sustainable forestry, including the SFI, the Sustainable Forestry Initiative, the LFA and its programs, and how you can be part of an organization that supports landowners, loggers, and the forest products industry in Louisiana, check out our website at laforestry.com. You can send comments or suggestions to me by email at jzeringue@laforestry.com. That's jzeringue@laforestry.com. You can also check out the show notes for our contact information as well as the contact information for our guests in this episode. You can send comments or suggestions to me by email at jzeringue@laforestry.com. That's jzeringue@laforestry.com. You can also check out the show notes for our contact information as well as the contact information of our guests in this episode. You can subscribe to Mind of the Forest by clicking on the subscribe button on your favorite podcast app. And be sure to tap the notification button as well. That way you'll know when a new episode drops each month. Thank you for doing that. We really do appreciate it. And remember, at the Louisiana Forestry Association, we're Mind of the Forest for you.